Hey everyone, I'm Matt Dolan with Dolan Divorce Lawyers in Connecticut, and today we're talking about premarital agreements in Connecticut, which are more commonly known as prenups. A prenup is a contract entered into by two people who are planning to get married. It lays out what happens financially in the event of divorce or death while the parties are still married. Now, a lot of people think prenups only address divorce, but they also cover what happens if one spouse passes away while they're still married. In Connecticut, a prenup can play an important role in estate planning because it can override certain default inheritance rights that a spouse would otherwise have under state law. Without a prenup, a surviving spouse is automatically entitled to a share of the deceased spouse's estate, even if a will says otherwise. But a prenup allows a couple to agree in advance on what each spouse will or will not receive if one of them dies. Now, this can be especially important for individuals who have children from a prior relationship, maybe they own a business or want to preserve certain assets for specific family members. Now, if you don't have a prenup, then Connecticut law controls the financial terms of divorce and also controls certain default inheritance rights when one spouse dies. While most couples try to settle their divorce cases, if they can't, a judge ultimately decides alimony, division of assets, division of debts, based on what the court considers fair and equitable. Many people choose to create a prenup because they want predictability. Their idea of what is fair may differ from what a judge might decide, and judges, being humans, can be unpredictable. A prenup allows the couple to define in advance what will happen financially if the marriage ends. Another benefit of a prenup is that it can make divorce less stressful and expensive. Divorces can take months or years, cost tens of thousands of dollars, and cause significant emotional strain. Now, a well-drafted prenup can streamline the process and reduce conflict and cost if a divorce does happen. Prenups in Connecticut are governed by the Connecticut Premarital Agreement Act, which includes several requirements for a prenup to be valid. First, the agreement must be entered into voluntarily. There can't be coercion or undue pressure. You can't force somebody to sign a prenup, and timing does matter. If someone introduces a prenup a week before a large wedding, for example, and it's already been paid for, the other person might feel they have no real choice but to sign the prenup, and that can make that prenup vulnerable to being invalidated at a later date by a judge. So the bottom line is that if you want a prenup, bring it up months and ideally a year before your wedding. Now, second, there must be full financial disclosure. Both parties must disclose their assets, liabilities, and income. Typically, this information is listed on a financial disclosure form that is attached to the prenup. This ensures that both people know exactly what they're agreeing to before they sign their prenup. Third, the agreement must be in writing and signed by both parties. That's pretty straightforward, but it is required. Fourth, both parties must have the opportunity to consult independent attorneys. This is another reason that timing matters. Each person should have enough time to review the agreement with their own lawyer. They don't have to have a lawyer, but in practice, both parties should have attorneys, as it greatly reduces the risk of a prenup being invalidated later. Fifth, the agreement cannot be unconscionable. A prenup can't be so one-sided that enforcing it would be fundamentally unfair, either at the time it is signed or at the time of divorce. So, for example, let's imagine that two parties have little money when they get married, and their prenup says that each person keeps their separate earnings that they accumulate during their marriage. If they stay married for 30 years and one spouse earns $50 million while the other party stays home raising the children and accumulates no assets, enforcing that prenup would leave one spouse with everything and the other with nothing, and a court would likely refuse to enforce that prenup. Now, invalidating a prenup based on unconscionability is a high burden, but if an agreement is grossly unfair, it can be invalidated. Now, finally, let's talk about what a prenup can cover. It can include division of assets and debts in the event of a divorce, how property brought into the marriage is treated, how property acquired during the marriage is treated, treatment of businesses or business interests, alimony, including waivers of alimony if both parties agree. However, a prenup cannot cover child custody or child support. These issues are always decided based on the best interest of the child at the time of divorce, and you can't predetermine that in a contract. Any attempt to limit child support or predetermined custody will not be enforced at the time of divorce. So those are the basics on prenups here in Connecticut. As usual, if you have any additional questions, you can contact our office. And if you are looking for help with the drafting or review of a premarital agreement here in Connecticut, we would invite you to contact our office as well.